The last few laws to be aware of in the Equal Opportunity Law is, first of all, the Age Discrimination and Employment Act, which argues we cannot discriminate based on age for those that are 40 or older. I can tell you you're too young to do a job, but I can't tell you you're too old to do the job. You know, we do find that the ADEA is being marginalized, largely because companies are making financial arguments. I'm going to get rid of these high-paid workers because these high-paid workers are hurting my budget, and therefore I can't seem to make payroll and I can't manage this. So given that they can't manage the payroll, they are asking the courts to give them permission to lay off these workers. But what do we know, right, about the relationship between payroll and employees, right? Older employees. Older employees make more money, as a rule. You know, the more time that you spend with a company, the more money you make, the more higher paid you are, the more likely you are to be in the higher paid echelon of the company. So as you get older and you broach 40 and you hit 40 or 50, and then the employer says to you, well, you make too much money, so we're going to fire you, or we're going to let you go. That's a problem. I mean, they can make all the legitimate, financial arguments that they want. I mean, ethically and morally, it's bull. And the bottom line is, what are you throwing away then? You're throwing away people that have an enormous amount of resources and information and knowledge about the company to make a financial argument. And again, when you think of people only as financial digits on your spreadsheet and not people that are invested in the business and not something to invest in, that's a concern. So that's how that basically works. So Americans with Disabilities Act passed in 1990, 1991, and the issue with the Americans with Disabilities Act, it was a way of ensuring that disabled Americans who were perfectly capable of doing jobs, were not being left out of the hiring pool simply because they had a disability. That it becomes this assumption that someone's in a wheelchair, therefore they can't do any job whatsoever. They're only limited. Well, why would somebody in a wheelchair be limited from doing other jobs unless it required them to walk all over the place? And of course, then they can't do that. Or, someone who's blind who absolutely needs to see what they're doing, and that there's no accommodation that can be made, in order to manage that. So that's the challenge there was, how do we accommodate and do a reasonable accommodation versus what can be considered to be an undue hardship for a company. And the relationship between those two things is very context dependent. There's not a hard and fast rule what is a reasonable accommodation versus what is undue hardship, because it depends on the company, depends on the extent of the accommodation that's being asked for. It could be that the accommodation might be reasonable if you're in a large business, but not so reasonable if you're in a small business, right? So there's all sorts of factors that have to be taken into account when you're trying to make a case for whether or not this might be considered a form of illegal discrimination. Your goal under the ADA is to ask people, right, can you do this job with or without a reasonable accommodation? Are you capable of doing this job with or without a reasonable accommodation? And the answer is yes or no. If the answer is yes, then you might not know until later what that accommodation might be, if at all. The goal is, can you do this job with or without the accommodation? If someone can do the job with or without accommodation, then later on they'll tell you, this is the accommodation I need. I need an amplifier on my phone, or I need to allow my seeing eye dog to be here in the office, or I need, to have a wider door so my wheelchair can get through. And how hard is that to be able to do that for people? I mean, again, a smaller business might have more financial difficulties being able to meet some demands. But by and large, most accommodations are only a few $100s. They're not unreasonable and they're not difficult. And here's a great example of a company who lost their argument that they would not make this accommodation for someone. An individual was a file clerk, and this file clerk had hurt his back. So he could do his job. His job is to file, right? He knows where to find files, how to access files, how to put away files. The one small part of his job that he had difficulty with wasn't dealing with the day-to-day of how to file, but when files were closed and they needed to be archived, he needed to gather the files, put them in a box, and then they got put up on a shelf somewhere. And he couldn't lift the box or put it on a shelf. So the company tried to say, well, you can't do the essential function of your job. Well, in which case, it's wrong. He can do the essential function of his job, because the essential function of his job is to manage the files. One day a month, he needs somebody to lift the box onto a file shelf. That's not an unreasonable accommodation, and it doesn't cost the company anything to ask somebody to help them to lift that box and to put the box of files up on a shelf. So he won his case because it was ridiculous that the company would refuse to help him because they thought that that was an unreasonable accommodation. So then we'll talk a little bit about more about the Americans with Disabilities Act in the next slide. So digging more deeply into the Americans with Disabilities Act, it's very clear on what is defined as a disability. It is considered a physical or mental impairment that limits major life activities. And okay, what's a major life activity? Breathing, sitting, eating, emotional processes, mental processes. So someone who's depressed would be covered. Somebody who's a recovering alcoholic would be considered covered because, all these things affect. Someone with a learning disability is covered. So all of these things are covered under the Americans with Disabilities Act as interfering with a major life activity, all right? So, if someone has a breathing apparatus, then they should be able to have they can do the job, but they need to have the breathing apparatus. There's no reason why they can't have it there, right? It's a major life function. So we don't want to discriminate based on someone having a disability in and of itself. But if the job requires you to be able to see something, and you have to see it and make it's a visual acuity, right? You need to have visual acuity, and you are legally blind, you can't do that. There's no accommodation that you can make that can help you do that, right? So that becomes a problem. You can't do the job if, and there's no accommodation that can be made. The function of the job requires this particular skill set, and you can't do it. Sort of like the adverse impact argument we were talking about before, right? In order to be a firefighter, you have to have these skills. If you don't have these skills, it doesn't matter if, how many women and minorities can't do the job. It's not considered discrimination. It's the same thing here. If you can't do what is required of that job and you want to change the thing, you don't get to change the job. You either have to be able to do the job the way it's defined, or you have to, find another job. So there are a couple of things that the EEOC needed to clarify in recent years. Number one is, recognizing that a physiological disorder may also have an effect on mental or psychological issues, and so depression and some organic brain diseases and things like that can be considered covered under there. Someone who had a heart attack, right? Someone who had a heart attack and is recovered, but people still think they are being affected by the heart attack, are also covered. So you don't have to have an actual disability. You have to be perceived to be disabled to be covered under EEOC and under the Americans with Disabilities Act. And an example of this is someone who has a heart attack and then they go through all their recovery and their heart heals and their heart's fine, no problems. Just because they had a heart attack doesn't mean there's a lifelong disability that's attached to it. So the participant has the disability, and then they come back to work and everybody treats them with kid gloves, and they don't get the really important job assignments, and they don't get promotions because everybody's worried they're going to have another heart attack. And the person has to say, I'm not disabled. My doctor will document. I have no problems with my hearts. I can do any job that I want to. I'm fine. I've healed. I shouldn't be limited from this job. That person is covered under the ADA, even if they don't have a disability. If someone thinks they do and treats them as if they do, then they are also still covered under that. So generally speaking, when we think about, what is a disability, that's the challenge. We have to figure out whether or not it affects a major life function. Then we have to figure out to what extent is an impairment, and to what extent does that affect the ability to do that essential function. If you can't do that essential function, okay, at all, even when there is no accommodation, if you need to see something, you can't see it. If you need to be able to walk and carry something, and you really seriously, the essential part of your job is walking and carrying something, you can't do that job. There's not an accommodation in the world that can help you. And just because you have a disability doesn't mean it gives you the right to have a particular job if you really can't fundamentally do the job. All right? So, there's no accommodation in the world that can change the fact that you need to see something and you can't see it. So, that is still a challenging law to litigate. It's probably one of the most litigated, in the short period of time it's been around. It's one of the most litigated pieces of legislation because there's a lot of ambiguity and a lot of contextual factors that go into play in what is, an accommodation, what is an undue hardship, what is a reasonable way of managing something, and what is a disability and what is not a disability. People would even argue some things are not really disabilities. It's just someone's inability to do something. I don't know how to tell you on that one, but that becomes the continuing argument about how do we define disability, how do we then figure out what the adverse impact is, and whether or not it's going to, have a, need a reasonable accommodation or something along that line. That's where our problems lie.